name is Craig Nash. I would like to welcome you to another It's a Grand Life. And I think you're really going to be blessed with this one. You know, when we became part of a grand family, there's many things that you and I did not count on when it came to raising our grandkids. And that was, would we have the skills and expertise to know what to do with our estate planning, with wills and trusts moving forward? Because the whole game changed when we became this grand family. You're not planning the 3 months in Florida that you thought. Now all your vacations are around your child's school calendar. And that's why our guest today is just going to be so fantastic to hear about what he's doing. His name is Eric Glick, and he's a legal specialist in the area of trusts, wills, financial powers of attorney, and all those things. And Eric, thank you so much for being our guest here on It's a Grand Life.
You're welcome. It's my pleasure. And I'm glad you broke things out like that, like trusts, wills, powers of attorney, because even with the term estate planning, not everyone knows what that means. So that's a good start.
Well, and I'm hoping you take the lid off all of those issues that we may know the terms, but we're kind of clueless as far as what they mean. But absolutely, the work that you do, Eric, is so vital to the survival of a grand family. And so can you tell us, tell our audience a little bit about the scope of work that you do at the Eric Glick Law Group?
Sure. So I've been an attorney for going on 27 years. And my practice primarily involves estate planning, the things you just mentioned, helping people with revocable trusts and wills and financial powers of attorney and medical powers of attorney and all the documents that go along with that. And also the probate court side of it. So if someone doesn't have an estate plan, we might go to probate court to get access to assets and get things distributed the way the rules of the state of Michigan say. And also, if we need conservatorships or guardianships for people that didn't do financial or medical powers of attorney while they were alive and competent to do it, we've got to go to probate court to make that happen. And also, probate court is where we go to fight over wills and trusts.
So there's an awful lot to that. And so why would a grand family need to talk to an estate planning or elder law attorney? Why would this interest us?
Well, so that's a good question. So, you know, in Michigan, I get asked the question a lot, and it might sound self-serving, but I believe everyone can benefit from an estate planning or an estate plan. Maybe that's the reason is different based on where you are in your life cycle, young children, older. But for grand families, it's even more important. You want to have the estate plan for the same reasons, which means someone is around to handle financial affairs for you if you want or need help. Someone can make medical treatment decisions if you can't make them for yourself. You want to use a trust usually to avoid probate court and control circumstances around distributions of assets and keep information private and avoid capital gains taxes and other types of taxes. But it's especially important with grand families because there's not automatic rights that a grandparent has. Spouses have automatic rights. Grand families don't. So it's important. Sometimes grand families may have some papers from a probate court, guardianships, conservatorships. Sometimes they don't. But whatever they have, it's even more important to get all these things taken care of. Guardianships, financial agents, medical agents, and then to distribute assets and hold them till the right time comes. With an estate plan, we can control who gets an inheritance and when they get it.
So do you think every grand family needs an estate plan? And or not? When do you draw the line?
Well, I believe everyone needs an estate plan. So I would include grand families in that same Venn diagram, so to speak.
Yes.
And it just depends on where you are. I used to say maybe with the exception of college children, everyone else can benefit from an estate plan. If you've got children, grandchildren, children you're guardian of, you need to appoint guardians if something happens to you. You also need to make sure, usually you have assets or maybe life insurance. You want to make sure the money's held for the proper time. So it goes to the children and they're not driving the fanciest Maserati at college. You know, they're driving a responsible car and the money's used to pay for college and to start a business and a wedding and those sorts of things. And so it's important from those perspectives.
And that makes so much sense. So, and what you said earlier, just really like a little light bulb went off for me, because grand families, we do not have the permissions or the authorization to automatically to make these to really lay out where everything should go, like a spouse will, or someone else, as you were saying. And so that would really prompt, hopefully, our listeners at home to maybe reach out to you and find out what exactly do I need in my situation. So you don't have to be own or run the Detroit Pistons to need an estate plan, right? You don't have to be the head of Rocket Mortgage to own an estate plan. You just need to have the monies that you want to make sure they go where you want them to go. Is that correct?
Yes. Yeah. So, yeah, people think of an estate as being that big mansion up on a hill behind the wrought iron fence, but it's not that. You need an estate plan for several reasons. I mean, number one, no one can get to a bank account if something happens to you. That's what the probate court is there for. Someone's got to go to the probate court and ask to be appointed a personal representative, be issued letters of authority, maybe post a bond. Then they can gather assets and submit an inventory of all the assets, pay an inventory fee, do all these things. An estate plan is going to make sure that your wishes are carried out. Like I mentioned, I don't want to keep beating it to death, but to make sure things are carried out, but also to make sure the person you want to be in charge is the person that's going to be in charge, because otherwise you don't know who's running the probate court to be the guardian after you. Sometimes with grand families, there's a reason the parents are out of the picture, and you want to make sure you've got a succession that things are covered. And, even just starting at square one, there's an assumption in my mind, and maybe it's a correct assumption or not, but grand families can even be informal. Oftentimes there may not even be a formal court action with the guardianship papers. Right. So that might even be a first step. And if it's not, then estate planning is even that much more important, because there's not guardianships. There's not that judicial determination that these are your lineal descendants necessarily.
Now, so I would imagine in your 27 plus years of practicing law that you have seen some kind of horrific situations with folks that didn't have an estate plan in place.
Oh, yeah.
What's that like? You get the call at the 25th hour that, hey, we're in trouble here.
Well, I do. I get those calls frequently. It's not unusual for me to go to a hospital or a rehab facility because someone is in very bad shape, and we can't go through the normal process of 3 or 4 or 5 weeks from beginning to end for estate planning. We got to get it done. Let's talk on the phone about what you want. I'll draft the documents. I'll meet you at the hospital. Make sure there's some people there to be witnesses. We get things done the same day. But the horror stories, run the gamut. Again, doing this for 27 years, people always come to see me when something doesn't go right. And we can fill a day with those types of stories, from procrastinating, from putting documents together without knowing what the law is on documents. I've had cases where people have tried to leave things to their children. So a woman had a home that her and her husband raised their children in, and was still living there after her husband's death with the stepfather. And she wanted the house to go to her children. And she told everyone she wanted the house to go to her 2 daughters when she died. And she even went so far as to draft a will. Well, okay. When she died, one of the daughters came to see me and said, my stepdad says he gets the house. What the heck happened? And mom thought she was doing the right things, but she didn't realize she can't disinherit a spouse by using a will. A spouse can elect to take what they would take if the will didn't exist. And that's what happened in this particular case. Even though he knew what his wife's wishes were, he didn't care, and he did what he wanted to do. So I see horrible things like that happen. I see fighting a lot. And it's just a matter of knowing what the law is and what you can do. And
it's got to be so frustrating to have a family call you in crisis after a family member has passed away, and the ducks were not in a row, and then you have to be the bearer of bad news, and they may be brand new folks you're meeting, and you have to say, no, you didn't have it in place, and no, mom does not get the house does not go to you, and it goes to the spouse, and there's probably hundreds of scenarios like that. So Now, what is the difference between a estate plan and a trust? Is that the same thing?
Well, an estate plan is one of the documents, or a trust is one of the documents in an estate plan.
Okay.
So typically we're concerned with different things. Some things while a person is alive, and some things when they're gone. So when you're alive, we want to have a financial power of attorney so someone can help with financial affairs. You want to have a medical power of attorney so someone can make medical treatment decisions for you if you can't. But then the second thing that we do with an estate plan is we want to make sure assets get transitioned properly. So that's where the trust comes in. Not everyone needs a trust, but many people do. And even if you don't need a trust, it's sometimes beneficial. So the way a trust works is I described how probate court works earlier, right? So if I've got a bank account in my name,
Right.
and I die, my wife can't go to the bank and say, I'm Jody, I'm Eric's wife, please give me the money. They have to lock down that account. So someone has to go to the probate court and ask to be empowered by the court to get access to that account. And then they can gather it, put it into an estate account, distribute it the way it's supposed to be distributed. A trust takes the probate court out of the equation because a trust is akin to a corporation or an LLC. And like a corporation or an LLC, it has perpetual life. It lives forever. So you're in charge as long as you're alive and well, but you name who's going to be in charge when you're not so alive or not so well. So you don't need to go to court to be empowered to access assets. The trust allows that to happen automatically. And as a result, you don't need probate court or the time and costs that go along with probate court. You're avoiding taxes, estate taxes, gift taxes, capital gains taxes that some people could put their family in the situation of paying if they use like these self-help methods, things like adding child's name to a house or a bank account or things like that. There's risks that go along with those sorts of self-help type planning. So a trust also gives you endless possibilities in terms of how to distribute assets. In my case, my trust provides that when my wife and I are both gone, my children receive 1/3 of their inheritance at age 25 and 1/3 at 30 and 1/3 at 35. There's no rule that says it's got to be those ages. It can be 10% a year for 10 years. It can be they get it when they retire, when they're 70. It can be, 80% at 23 and 20% at 27. It can be whatever you want. But the nice thing is that trust allows you that flexibility to plan those things out.
Now, Eric, like this is what you specialize in. So I want to ask you, how did you and your wife pick that time frame for your kids? That you've just done hundreds of these, and this is what you've seen has worked in the past, or?
A lot of things went into it. So I used to clerk for Judge Thorburn at the Oakland County Circuit Court when I was in law school 28 years ago.
Okay.
And I guess he was chief judge from time to time. And when he was chief judge, he would go and tour some of the local jails and meet wardens and things. And he would tell me, when do you know someone's rehabilitated? When are they ready to be released? And a lot of times the wardens would say, well, when someone turns 25, seems to be when something clicks, their brains are fully formed. I think the brains being fully formed kind of came around later. I think years ago, maybe they didn't have that study, or maybe they did.
Yeah.
But so that's really the first step. So first step, 25 is a good starting point. And then it's the 3-strike rule. If you blow it when you're 25, you get another shot when you're 30. And if you blow it when you're 30, you've got another shot at 35. And then just the rules, Darwin's theory after that point. But also the way I have my trust set up, and when we do it this way with the ages, is that the children aren't locked out of the money until 25 and 30 and 35. The trustee, whomever that might be, has discretion to use money before those ages for HEMS, for health, education, maintenance, and support. So there's always the availability of money. In my case, my brother-in-law would be the successor trustee if my wife and I are gone, and he's going to hold the money until those ages. And with a trust, one of the nice things is we're talking about a revocable living trust for estate plan purposes. So a living trust means we create it and we fund it, put things into it during your lifetime, or at least make sure things are going to go into it automatically upon death. And then a revocable trust means it can always be amended. So when my children are older, I don't plan for my brother-in-law to be in charge forever. When my children are older, I'm going to amend my trust and put them in charge.
Gotcha.
And
that makes just so much sense. But Uh, how important, when you're putting the trust together, is transparency among the family members with the grandparents and the successors and what have you? You recommend getting everyone sitting around the table, I would imagine, and saying, this is our thoughts, and this is where we'd like things to work out and or to be distributed. And that's got to be so much more helpful than folks getting a letter after someone's passed on. Is that?
Yeah.
Yeah.
Yeah. Getting back to your questions of things I've seen, I've seen children get upset for in my mind, unimportant reasons. The order of children or grandchildren, who's
Right.
going to be in charge. Why is this person first? And why am I the backup? Why can't we both be co-trustees or co-agents?
Right.
That's a big one. Also, I've seen things with medical powers of attorney, for example. I mean, you want to have transparency because you want to make sure the person you're thinking of using are interested and willing to do what you want them to do, because
Right.
sometimes people say no. I had a case where I was representing a woman, and she was maybe in her 80s, and she had adult children, and she wanted to bring all the girls in to go over the documents at the signing meeting. And as we're going through them, this is the person who's going to make medical decisions and other decisions. The girl whose first choice is patient advocate chimes in and she says, "Have you talked with Father Mike about this? Because that doesn't sound consistent with our church principles." And I'm thinking, uh-oh. If you're going to have like a patient advocate designation that says pull the plug, I don't want to be kept alive by artificial means, you don't want to have a patient advocate who's got religious or moral objections to doing that. So you want everyone to be on the same page.
That's the wrong choice, right? I mean,
Right.
the heart's in the right spot, but that's not what mom or dad would have wanted. But now, in the grand family arena, unfortunately, we have a lot of kids that have given us these wonderful grandkids that may have behavioral health or substance abuse issues and what have you. And so these trusts and estate plans may have to be modified from time to time. Is that hard to do?
No, I mean, typically we have trust be flexible so it can contemplate all those things. And so my trusts usually have provisions that if a beneficiary has creditor issues or drug or alcohol issues or gambling issues or something like that, we can protect money. But if we really know going in, especially if someone is receiving government benefits,
Right.
so government benefits like SSI or Medicaid, something that's based on need, if we just leave them in inheritance, it could disqualify them from their benefits because a single person can't have more than $2,000 of countable assets. So that's where a special needs trust comes in. So it's the same trust, but now when the creators of the trust are gone and you're distributing assets to the beneficiaries, the beneficiary who's receiving government benefits, their share gets held in what we call a special needs trust. So the trustee has discretion to use as much or as little as the money as is necessary to supplement what the government's paying for, not to replace it. And so what makes it a special needs trust is that, plus we use special language that sort of survived government scrutiny. It's passed muster when it's looked at by Medicaid or SSI, and it withstands their scrutiny. And of course, some people don't have issues and aren't needing benefits or don't have reasons they need to be protected, and they develop them later. So we can always do amendment to the trust one way or the other. A revocable trust can always be amended by the people that create it, not by anyone else. So it's locked in. You don't have to worry about someone else changing what your wishes are and what happens when you're gone. But as long as the person that creates the trust has mental capacity, they can always modify the trust.
That is so important to know. And there's another component I would imagine, and that is maybe a tax planning side. Do you get involved in that, or do you work with folks that specialize in that? How does that work?
Well, I'm not a financial advisor or a tax accountant, but there are some tax implications that come into play with estate planning. So right now, people don't typically have taxable estates because you're allowed to leave almost $13 million per person under the Internal Revenue Code. And the state of Michigan's estate tax rules mirror the federal. So it's the same, almost 13 million. And if you're married, you can shelter almost $26 million. So not many people have taxable estates from an estate tax perspective. But we want to make sure that when you're transitioning assets after death, that you're avoiding capital gains taxes and gift taxes.
Right.
And even you can minimize or you can work with income taxes to some extent, because remember those IRAs and 401ks, whoever takes the money out, whether you take your own money out, whether the surviving spouse takes the money out, whether beneficiaries take the money out, there's income tax consequences with those. So we're always aware of those sorts of things. But by having a proper estate and by using a trust, we can make sure that you're avoiding capital gains taxes. Because if you leave appreciating assets like bank account, brokerage accounts, stocks and bonds and a house to someone upon death, they get a stepped up basis. Their basis in that property is date of death value. So they don't have to pay estate taxes or pay capital gains taxes. If, however, as an alternative, because there's always someone out there saying, hey, forget about all the fancy schmancy estate plan. Just put your kids' names on your bank account, your brokerage account, your house. If you do that, you're making a gift that may have gift tax consequences, and you're also locking in their basis. So now if that asset appreciates, they've got capital gains and they've got to pay capital gains taxes. We can avoid all that by using a trust because you're leaving those assets to your beneficiaries upon your death. They're not lifetime gifts. And under the current Internal Revenue Code, you get that step up in basis, or they get that step up in basis. That's a real great benefit.
That makes so much sense. And I'm hoping if you're listening to this at home, you're starting to realize that, you probably need to chat with someone about your estate before things change. And our guest today, Eric Glick, knows this backwards and forwards. He's been doing this for 27 years. And in fact, you could even drop him an email at ericglicklaw@gmail.com, or you could call Eric at 248-220-1423. But the main thing is we can't let things go the way they have been going for the past 10, 20, 30, 40, 50 years, whatever age you're at. You need to have a plan. And, one part of living a grand life is knowing that everything is in its place and everything has its order. And having an estate plan and a trust in place is going to make sense for, I would imagine, all of our listeners. And Eric, I can't thank you enough for being our guest today on It's a Grand Life. And if folks want to contact you, it's okay to reach out to you from an email standpoint or call your office, or that's the best way to get you, right?
Yeah, it's a pleasure to be here. They can call my office. The office is the Glick Law Firm. The number is 248-220-1423. And I also have a website people can check out. It's ericglicklaw.com. And they can get my phone numbers and other contact information there. And by the way, it's Eric with a C, E-R-I-C.
That's right. That's good. So, Eric, thank you so much for being our guest today. And I hope as things change in the estate planning, probate world, that you'll come back on and keep us posted on those new changes in the laws. We'd love to hear from you. And thanks so much for being our guest on It's a Grand Life.
I absolutely will look forward to letting you know if there's any changes. And when we have an election coming up, so I'd be happy to talk about what happens at that election.
Oh, that would be absolutely great. But thanks for all your time today. And I know you've been a real blessing to our audience. So we look forward to seeing you next time on It's a Grand Life. Thank you for joining us for another It's a Grand Life. Remember to never waste your pain. God can use your situation to bless others even halfway around the world. Be sure and subscribe to It's a Grand Life on our Facebook page, as well as YouTube and any of the various podcast channels that feature the Grand Life podcast. When it comes to raising a grand family, remember the words of the Apostle Paul, who said in 1 Corinthians 13, "Love is patient, love is kind, it always protects, always trusts, always hopes, and always perseveres. Love never fails." In leading your grand family, it's going to take faith, hope, and a whole lot of love. Please reach out to me. I can be a blessing to you and pray for you, or help you connect to free resources that can make your journey a little easier.